to our webinar with the name of The Use of American Federal Discovery Tools to Obtain Evidence for Use in Mexican Legal Proceedings. Now I'm going to introduce you our excellent panelists. First of all, we have with us Mark Zebrowski from Morrison and Foster. He is from San Diego. Javier Rubinstein from King and Spalding from Chicago, Illinois. Victor Muskin from Muskin Law Offices from New York. Geoffrey Morrison, a U.S. international lawyer from Cambridge, England. And my partner, Jorge de Hoyos from the Hoyos Avilés. I am Karla Hernandez, and I'm also from the Hoyos Avilés, and we are very proud to have this webinar with you. I'm going to give the word to Jorge.
Hi, good morning to all of you. America is Mexico's main trading partner. The economies of both countries are connected in several production and supply chains. Commercial contracts with effect in both countries occurs day by day. Attorneys with a cross-border practice need to understand not only the law of their country, but also international treaties and, moreover, the domestic law of other countries where their clients are doing business. There is an additional fact. Business and personal relationships between Mexicans are usually connected to the United States. There is an interesting book by Andrew Seeley entitled Vanishing Frontiers, in which the author explained this process of integration, especially along the Mexico-USA border. This integration of economies and personal relationships presents a great challenge for trial lawyers in Mexico. In civil and commercial litigation, it is sometimes critical to obtain evidence outside of Mexico. The tools provided by Mexican law are limited. On the other hand, Mexico is party of the Hague Convention to obtain evidence abroad. But Mexico made important reservations regarding the discovery tool. Therefore, the Hague Convention has limited utility in Mexico litigation. And it is precisely at that point where American federal law can become a powerful tool for Mexican litigants. Without further comments, I will leave to the expert to give us a complete overview of the options available in USA. Mark, welcome and please proceed. Mark?
Yes, I had to unmute myself. Sorry, Jorge. It's the perils of working remotely. So the first thing I'm going to talk about here is what is discovery in the United States. So for transactional lawyers that may not do a lot of litigation, or for Mexican lawyers that may not have a lot of experience in the United States, I'll give you an overview of what is available here. And I'll just note, when I work with foreign clients in particular, or clients that have not had a lot of litigation experience, they're usually quite surprised at how broad this is. So discovery in the United States is the legal process for obtaining evidence in connection with litigation. We have two purposes, broadly speaking, for this. One is so that each side can get the evidence, know what it is, and prepare for trial. So we don't have trial by surprise, typically. We have trial where everybody knows the evidence going in. The second purpose is to encourage, settlement. So rather than sitting back and not knowing that you have weaknesses in your case, you may learn about it, or strengths in your case, and encourage parties to settle. So what is the scope of discovery? So discovery, again, is your ability to get information, documents, etc. from the other side. It's a very broad standard in the United States. The general standard is you're entitled to get evidence that is relevant or reasonably calculated to lead to the discovery of admissible evidence. And just suffice it to say again, that's very, very broad. Most judges will give litigants a very broad scope to obtain potential evidence in connection with a lawsuit. How do you do this? There are four general types of discovery tools available here. The first one is a deposition. We're going to be following, for today's seminar, the Federal Rules of Civil Procedure, and this is Rule 30. So a deposition is an in-person oral questioning of a witness who is sworn to tell the truth. I say in person, these have been done by Zoom and remotely during the pandemic. Depositions can be taken of party witnesses, a particular individual or an entity, and they can also be taken of non-party witnesses. So if there's a traffic accident and someone was just standing on the street corner and saw it, that person can get their deposition taken as well. The witness is entitled to have their own lawyer present. The lawyer is entitled to raise and state objections on the record, but for the most part, that does not stop the examination at all. You're still entitled to a very broad examination. In addition to setting up a deposition, you can request that the witness produce documents at the deposition. So, for example, bring emails back and forth between the witness and one of the parties. Another interesting tool here for depositions, you can depose an entity. And so, for example, if you have a case against a corporation and you want to take that corporation's, you want to know what that corporation knows about a particular contract or knows about a particular financial situation or the like, you can notice the deposition of that corporation and list the topics that you want to depose the corporation on. And that obligates the corporation to produce a witness for you who is knowledgeable on those topics. And they need to actually get themselves knowledgeable. So let's say you want financial information, they have to send somebody there who is knowledgeable about that information. They can't just send somebody who says, I'm the chief financial officer, but I'm not familiar with those documents. So it's a very powerful tool as well to get to an entity, because you don't have to even know who the witness is. The entity has to figure that out for you. In a deposition, a written transcript is created. All the questions and answers are taken down. You can also videotape and audio tape a deposition if you notice it. When I say notice, that's setting it up, giving people the notice that they must appear. If you notice it to be videotaped or audio taped, you can do that as well. And then the deposition transcript or videotape can actually be used as evidence in trial. You can simply read it, or you can show the video in trial, particularly if the witness is unavailable. And when I say that, keep in mind that it is subject to evidentiary objection. So if, for example, you ask a question in the deposition, the other side objects, that question must be answered in the deposition, despite the objection for the most part. However, the judge will rule on that objection at trial. But generally speaking, you take a deposition, you get the sworn testimony, and you can use that testimony as evidence in trial. The second tool is a request for production of documents or other things. And that's our federal rule of civil procedure.
Mark, may I have a question for you?
Yes.
Yes, to give a background to Mexican practitioners, we are getting used in Mexico to have all the depositions in court, but this is not the case in the United States. Can you just give us an idea of how this works?
Correct. So typically what would happen if you ignore the pandemic for a while, if a person is in San Diego, I would typically have that person come to my office in San Diego, or perhaps if they had a lawyer, I might do it at the other person's office. If the witness or the corporation, for example, is in Boston, then I would go to Boston and I would set up a place in Boston outside of a courthouse, either at their office, which can happen sometimes if that's what they'd like, or at another law office. Or these court reporting companies have their own offices and they'll provide space for you so you can bring the witnesses to the deposition. Also, keep in mind, Jorge, does that answer the question?
Yes, absolutely. Thank you.
Yes. Keep in mind also that even though these depositions happen in a private facility rather than the courthouse, technically they are a public proceeding. So if someone says they want to come to a deposition in my office, I can keep them out of my office because it's a private office. But a party is always entitled to be at the deposition. So if you have a client and you're going to take the deposition of some American witness, your client is entitled to be at that deposition. And so that's can impact how these depositions proceed as well. Okay, number 2, request for production of documents or inspection of things. So you can send a discovery request that says, please give me all emails between Jorge and Mark. And the other side, the receiving side, has to do that. They have to take a diligent search to find those documents. You can put multiple categories in the request. And this can also be sent to non-parties. So a deposition, and I failed to mention that, a deposition can be taken, I think I mentioned, of parties, or non-parties. Same thing for request for protection of documents. You can send those to parties. You can also request documents from third parties by subpoena, separate from a discovery request to a party. However, you have to have a lawsuit pending in order to issue that subpoena. So you would probably need help from a U.S. court for that as well. You can specify the form in which electronically stored information is to be produced. So today, most documents tend to be electronic. You can specify the format, for example, native format. You can request production of metadata, which can also be very, very valuable to actually figure out when a document was produced, how it was produced, when it was altered, and the like. In addition to documents, I mentioned inspection of things. So let's say, for example, you have a case in which somebody was injured by a tire failure, and that tire is somewhere. It's maybe with a lawyer, or maybe with the tire company, or maybe somewhere else. You can request that that tire be made available for you to test and inspect. There'll be some restraints on that, perhaps. You can't do destructive testing and alter the evidence without approval of the court. But you can get things in addition to documents. The third tool, is interrogatories. That's Federal Rule of Civil Procedure, Rule 33. Those are written questions that you send to a party, only to a party, that party must answer under oath. And so you can say, how fast were you going when you hit the other car? And that person must say, I was going 40 miles an hour. Or if it's true, I don't know. But they must certainly answer truthfully the question. They must answer it completely. You can ask contention questions. So, did you breach the contract? Yes or no? Those are legit. And these can only be directed to a party. And the answers can be read as evidence at trial. So if someone says I was going 40 miles an hour, you can simply read that to the jury or the judge and tell the jury and the judge that this person was going 40 miles an hour in a 30-mile-an-hour zone because they answered their interrogatory that way. The fourth written tool is called the requests for admission. That's Federal Rule 36. This is similar to an interrogatory, but it's a straight out request that you admit or deny something. So admit that you were speeding. Yes, no. That you were going faster than the speed limit. You can also request admissions of the application of law to fact. So you can ask, admit that you breached the contract. You can also ask requests for admission that amount to opinions. Admit that you were negligent. Admit that you fell below the standard of care when you did this. And another thing people will often use requests for admission for is to essentially lay the evidentiary foundation for documents. So you can ask, admit that you wrote this email to Jorge on June 10th of 2020. And then you now have everything you need to get that document into evidence under our evidence rules. Another tool that you can use is use the request for admissions along with interrogatories. So you might say, admit that you breached the contract. That's your request for admission number one. Your interrogatory number one can say, if you deny that you breached the contract, tell us all the facts on which you base your denial, or tell us all the witnesses, all the documents that support your contention. These admissions, again, just like the interrogatories, they're binding on the party. So you can go into court and say, yes, he admits he breached the contract. These, like interrogatories, also can only be directed to a party, not to a non-party. So those are the big tools. And I mentioned it's very, very broad. What are the limitations on discovery? First of all, there are statutory limitations under the Federal Rules of Civil Procedure, so that it doesn't get too onerous. Each side gets 10 depositions, and each side gets 25 interrogatories, unless the parties agree to more and the court gives you more. So you can tell the judge, I have a complicated case, I need 15 depositions, and if you can convince the judge, you'll get the 15 depositions. Another limitation, again, without permission from the court, is you only have 7 hours on the record to complete the deposition of a particular witness. So you basically get 1 day with the witness. Limitation number 2 is privileges. So I mentioned attorneys can object in a deposition, for example. For the most part, that will not stop the questioning and answering. The witness must answer. However, if I say, for example, tell me what your lawyer Jorge told you about this, there should be an objection there on the grounds that that is attorney-client privilege, and that question would not be answered because it is privilege. So the discovery is limited, of course, by privileges like attorney-client privilege. Another limitation is if discovery gets too burdensome, then a court may either limit the discovery or shift the burden of the discovery. So, for example, if it's going to take a ridiculous amount of man-hours to gather documents, and it's going to be hundreds of thousands of pieces of paper, the court may or may not limit that. It will depend on the circumstances. If you have an antitrust case against Apple, the court's going to expect there's going to be a lot of documents. Tough. That's the way it's going to be. But if it gets too burdensome, the court may say, no, you don't have to do quite that much work. So the court may, for example, say, all right, let's confine this to a certain time frame, or let's confine this to certain search terms or certain witnesses, and we'll start this and do it in more bite-sized pieces. Or the court may say, all right, Jorge, if you really want all that documentation from Apple, you're going to have to pay Apple's costs to pull all that together. So there are limits as it gets too burdensome. Another limitation on discovery is this, is confidentiality. So if the information being requested, for example, in a patent case, it may be highly confidential proprietary information, that won't stop discovery. What it will likely do is result in a court issuing a confidentiality order or a protective order, which will put restrictions on how that information can be used and who can see it and what happens to it after the litigation is over. So, for example, it might say these types of documents can only be seen by outside engineering and software experts, and at the end of the lawsuit, they must be destroyed or returned back to Apple, for example. So those are the primary limitations. The number of discovery requests you can use, cannot invade privileges. It at some point may get too burdensome. And again, don't hang your hat on that one, because courts are happy to impose quite a bit of burden in the United States. Their discovery is, as I mentioned, very, very broad. And then confidentiality and protective orders. So if you represent a client that is facing one of these requests, keep in mind those are the limitations, and protective orders are routinely issued. So in fact, there's forms for them in many of the federal courts. They have their preferred protective orders. Okay, what is the duty to respond to discovery? If your client is served with it, or if you issue it, the duty is broad. So person being hit with discovery has to provide honest, accurate, complete, non-evasive responses. That includes undertaking a diligent search to produce all non-privileged responsive documents that are in that person or that company's custody or control. That may mean even going somewhere else to get them sometimes, because let's say I have an appraisal for my property, but I don't have it. The appraiser has it. And you ask me to give you all copies of all documents that relate to the value of my property. I may need to go to that appraiser because he's my appraiser. And so that appraiser is in my custody or control. So that applies not only to documents, but to requests for admissions, interrogatories, depositions. You must provide honest, accurate, complete, non-evasive responses and undertake due diligence to do that. What if you don't? How is discovery enforced? Our courts enforce discovery obligations. Violations you can think of would be, for example, failure to respond at all, or failure to respond fully, honestly, accurately, and diligently. Courts will issue enforcement orders here. The most basic one is to compel compliance. So it's typically a two-step process. The court would say, yes, you must respond, or you must respond more fully. Even in that initial stage, the court may award monetary sanctions against the person or the company who did not fully and properly respond. Those sanctions might be awarded against the party or the witness. That's most common. They may also be awarded against the party's counsel if the court is of the view that the counsel was responsible in part for the inadequate responses. The next elevated level would be contempt of court, which again can result in things like sanctions, financial sanctions, and actually can go all the way up to incarceration. Very, very rare, but it's possible. And then in the U.S. courts, the courts will also issue evidentiary sanctions. So it would mean, for example, if I do not give an honest, accurate, complete response to a request for admission, and I have still not done so after being ordered to do so, the court might issue an order, for example, that says that fact is deemed admitted by me. So if you have asked me to admit that I breached the contract and I failed to give a proper, adequate response to that, at the end, the court may say, all right, as a sanction, it is deemed for the rest of this case that you breached the contract. So you can get what we call evidentiary sanctions. And then the highest level of sanction is striking your pleading. So for example, if a plaintiff fails to eventually properly respond to discovery, they could get their lawsuit thrown out of court. If a defendant fails to properly respond to discovery, they may get a default judgment entered against them. So essentially the plaintiff wins, and then it's just up to the plaintiff to prove what their damages are. So Jorge, unless there's any other questions, that's it for me.
No, yeah, I believe you were at the end of the time. Just one last question about the rules of professional conduct of the attorneys. I mean, because the standard in America is very high for attorneys. Yes. So let's say, for instance, that your client is required to disclose some emails, and you are the lead counsel in the case. So can you play games and advise your client, hey, do not disclose this document because this can harm our case, or which are your obligations as lead counsel?
Absolutely not. So let's say you do that as a lawyer here. You can get sanctioned by the court. So, for example, you can get monetary sanctions. You get fined, and they can be pretty big. You can also get in trouble with the state bar. We have extremely high ethical obligations. Now, let me also say this. We also have our jobs to do. And so people will raise objections, and people will say, wait a minute, I think that's too broad or too burdensome. But if it has been requested, then it exists. And we also have an obligation to do more than just simply say to our client, well, get your documents together. We have an obligation to make sure they do that, and to make sure that, for example, in today's world of electronic discovery, we have obligations, at least in California, to be competent ourselves in the process of gathering and assuring complete collection of the documents, reviewing the documents, making sure that they're all produced. And if we're not technically savvy, we have an obligation to have someone on our team, whether it's a really smart associate or paralegal, or we actually, in our firm, we're a larger firm, so we have people in-house who are full-time employed, not lawyers, but they are IT specialists that work with our clients and our clients' IT departments to make sure that the proper servers are checked, to make sure that the proper searches are run, to work on search terms, make sure that, for example, if there's 10 people that might have emails on this subject, that all 10 have their emails searched and collected. And then we also have outside vendors who make a living doing nothing but assisting with discovery. So they're technical people. They have databases, they have software to search and collect and the like. So we have extremely high obligations. And I've been lucky in my career for the most part. I have not seen too much cheating, if you will, but it's not to say it doesn't happen. I mean, and that's why if you are involved in one of these, you want to be diligent if you are a requesting party, to be careful and conscious to make sure that it looks like you got what you should be getting. I've got a case right now where, and it's not the lawyer's fault, I'm sure it's the other side's, the party's fault, but we were supposed to get data from the other side that they have our software, and the data should be generated by our software, and it should have come off 6 servers, and we got the data, and my client's technical people are clear that we don't have all the data from the other side. So it happens, but
Okay.
to your question, we have extremely high obligations.
Okay, thank you very much. Thanks, Mark.
Thank you very much, Mark, for this interesting topic about the introduction of what is discoverable. Now we will proceed with Javier Rubinstein. He will talk to us about the overview of on 1782 rule and the aspects related to it.
Thank you, Karla. So yes, I'm going to talk about Title 28, Section 1782 of the Federal Judicial Code. It's a statute that gives parties who are involved in foreign legal proceedings the ability to seek the type of discovery that Mark just described from parties that are located in the United States for use in the foreign proceedings. And so in this particular context, what we're focusing on is the ability of parties to Mexican legal proceedings to be able to obtain discovery in the United States pursuant to this statute for use in the Mexican legal proceedings. It is a powerful tool that parties should be aware of, as it can provide a substantial source of information for use before Mexican tribunals, including information that could not be obtained in Mexico for the reasons that Jorge described. So what I'm going to do is I'm going to give a short overview of how Section 1782 works. And my colleagues are going to cover some specific points as well that you should be aware of in considering whether Section 1782 is an available tool. So the way that Section 1782 works is that there are 4 requirements that are set out in the statute itself and that must be met in order for a party to be able to obtain discovery under Section 1782. If those 4 requirements are met, there are then a number of discretionary factors that the Supreme Court has identified that will allow a court to decide whether to grant the discovery that's been requested and how much discovery to order. The order of discovery is discretionary, so just because the statutory requirements are met does not obligate the court to grant the requested discovery. So what I'll do here quickly is run through the statutory requirements as well as the discretionary factors that courts will regularly consider. And I understand that there will be a distribution of materials to participants, so these will be set out in a presentation that I put together that you can take a look at. So what are the 4 requirements that must be met in order for parties to foreign legal proceedings to seek discovery under Section 1782? The first is that the person from whom discovery is sought in the United States must reside or be found in the federal district where the court is located and where the application for discovery is made. Now, the question of what it means for a person or a corporation to reside or be found in a district is not entirely clear. We do know that if a company, for example, is incorporated or has their principal place of business in the district where the application is made, that requirement is met. But in addition to that, if a corporation has its principal place of business or incorporation somewhere else, that corporation can also be considered to be found in the district if they have some type of presence in the district and the documents that are sought relate to the activities in the district. So this is where the ambiguity around the scope of the statute exists and will likely continue to be addressed by the courts. The second requirement is that the discovery that is sought must be for use in a foreign legal proceeding. Now, this requirement is usually pretty straightforward, and in effect, what it requires is that the applicant for the discovery must have the ability to present the requested information as evidence in the foreign legal proceeding. The third requirement is that the foreign proceeding must be before a foreign tribunal. It is clear that a tribunal would be a court or perhaps an administrative tribunal. That is also clear. Where the controversy currently exists is whether or not the statute also covers arbitral tribunals. If you're talking about a commercial arbitration, the federal courts are split over the question of whether Section 1782 applies in the case of international commercial arbitrations or even domestic commercial arbitrations. Some courts have said that it does, other courts have said that it doesn't. So at this point, when if you are looking to obtain discovery for use in an arbitration, you have to look at how the court in the particular district where the respondent is located, how they have ruled on that question. We do expect that the Supreme Court will ultimately decide this question, and it is difficult to say at this point how the Supreme Court will decide that question. If you are involved in an investment treaty arbitration, though, it is clear that the statute would apply because that tribunal is created by a treaty as opposed to the private commercial agreement of parties. The fourth requirement is that the application must be made either by the foreign tribunal or by an interested person. Typically, this is not a contested issue, but essentially an interested person would be a party to the foreign legal proceeding. So these are the four statutory requirements that must be met in order to obtain discovery under Section 1782. But as I mentioned, just because you meet these requirements does not guarantee that you will be able to get the discovery that's been requested. The court will then apply a number of discretionary factors to decide whether to grant the application and how much discovery to permit. These factors were set out by the Supreme Court in a case in 2004 called Intel, and so I'll just briefly summarize them for you. The first discretionary factor is whether the discovery that is being sought is within the foreign tribunal's jurisdictional reach, and whether a party could obtain that discovery without the need to go through Section 1782. If, for example, the foreign tribunal would have that ability and denied the application, that would be a relevant consideration for the court in deciding whether to grant the requested discovery. The second discretionary factor is the nature of the foreign litigation and the character of the proceedings that are underway, and also the foreign country's receptivity to judicial assistance from the United States. Here, what courts look at is whether or not principles of due process are being respected in the foreign proceeding, and they will look at whether or not the tribunal would be willing to receive the requested information as evidence in the proceeding. The third discretionary factor is whether the request for discovery reveals an attempt to circumvent proof gathering restrictions in the foreign country, or whether it would violate policies of the foreign country. Now, this does generate a little bit of confusion because this requirement does not mean that the information that is sought in discovery has to be discoverable in the other jurisdiction, or that you first have to try to obtain the information in the other jurisdiction. That is not required. As has been already mentioned, discovery procedures in civil law jurisdictions like Mexico do not envision the type of discovery that Mark has described. And so It is most often the case that the information that is being sought in discovery under Section 1782 is information that could not be discovered under the procedures of the foreign jurisdiction. Typically, where this factor becomes relevant is where the matter of discovery has been presented to the foreign tribunal, and the tribunal has said that it will not allow this type of discovery to be obtained and will not consider this information if it is obtained. And so this is a factor that ought to be thought about from a strategic standpoint if you are going to seek discovery, and perhaps we can talk about that later in the webinar. And then
Javier,
yeah.
Javier, one question, please. If we have a conflict here in Mexico only between Mexicans, so there is no American or American companies or American citizens involved in dispute, but we have two Mexicans fighting in Mexico, but they have companies and they have assets in the States, and one of the party wants to disclose information about those companies because maybe that those American companies are related with this conflict. So can we use this rule 1782 even with the conflict is only domestic in Mexico?
So if it's a really good question. So first of all, the statute clearly does apply to foreign proceedings that have only parties, non-U.S. parties. So if you had a Mexican litigation where you had Mexican parties on both sides, the statute would apply. And so there's no need for there to be a U.S. party to the foreign legal proceeding. The question, though, it's an interesting question. We actually had this come up in a case where I represented a group of Mexican parties in an investment treaty arbitration last year in the Second Circuit Court of Appeals. If you have, for example, one of the parties in Mexico is a company and it has a subsidiary in the United States, right, and you were to go to the location, to the district where that subsidiary is located, the question of whether you would get that information, it's unclear. I mean, if the documents that are sought from the subsidiary are documents that relate to the activities of the subsidiary in that district, then in all likelihood, you would be able to seek that discovery. If, however, you are using the presence of that subsidiary to get access to documents that are located in Mexico, for example, that would be a tougher question to decide. What typically the way this comes up is that if there are assets, for example, bank accounts in the United States, and parties want to get information about the assets that are present in that district, it is very common to utilize Section 1782 to seek discovery from the bank. I mean, a third party that is not a party to the litigation, in order to get information that could be utilized for the litigation or the arbitration potentially in Mexico. And so I think it's really important, I mean, to underscore for Mexican counsel that are listening that this statute applies to purely domestic legal proceedings in Mexico. And so which is why often the statute is not thought about. And the assumption is that in order to be able to access the statute, there has to be some connection between the litigation and the United States. That's not the case.
Let's think for a moment in a probate case or a divorce case in which both parties are Mexicans, but they are home in San Diego or Houston or Miami, and more assets. But the case is the divorce case entirely in Mexico. Can we use this tool to track the assets?
So if there are assets that are located in the United States and there is a third party that has possession of those assets and you want information about those assets, and that information is relevant and could be presented in the divorce proceeding in Mexico, then yes, potentially the statute would be available. But again, you have to meet the requirements of the statute. The important point is that the discovery has to be related to activities or information that is located in the district and is in the possession, custody, or control of whomever it is that you are seeking the discovery from. But yes, and then the example you gave is one of the most common. It's where there is a purely domestic proceeding, but there are assets located in the United States, and there is a need to get information about those assets for consideration by the Mexican tribunal. That is a prototypical example of where the statute is utilized. The last point I'll make, and then I'll stop, is that the last consideration, discretionary factor that the Supreme Court has identified, and this goes back to something that Mark was referring to, is whether the requested discovery is unduly intrusive or burdensome. If the discovery is viewed as too intrusive or burdensome, that objection can be made. And the court, if that objection is made, the court could deny the discovery on that basis, or it could narrow the discovery if the court believes that to be appropriate. And so that is a common issue that is debated in 1782 cases. But it is important to underscore that if the requirements of the statute are met, the federal discovery rules that Mark described are the rules that generally will be applied to a discovery process under 1782. So let me stop there and be happy to answer questions later.
Thank you very